just a few words about my mandate. Special rapporteurs are part of the so-called special procedures of the Human Rights Council. We are basically independent experts. We are not paid for our work, which means that we are not only independent from member states, including our state of nationality, but we are also independent from the UN bureaucracy, in the sense that our relationship with the bureaucracy is a functional one. The Office of the High Commissioner provides us with minimal staff and budget for our travels, for the official activities of our mandate. I report twice a year. Once to the Human Rights Council, and the second report is for the General Assembly, which is interesting because not all special rapporteurs report to the General Assembly, which means that trafficking is considered an integral part of the peace and security agenda. These are thematic reports, so I try to highlight aspects that have been overlooked or not adequately addressed. In addition, I attach the report on the most recent country visit, because I carry out country visits with the final report and recommendations. As far as I can, I try to follow up to these recommendations and try to push for some changes or reforms. The subject of this lecture, as Siobhan said, is especially focused on trafficking, on challenges related to a human rights approach to trafficking and anti-trafficking action in conflict context. But before going through the center of this presentation, I would like to say just a few words about trafficking, about the phenomenon of trafficking and the legal definition of trafficking. Trafficking today is considered a modern form of slavery. There is a discussion about, slavery comprising trafficking or the opposite. This is not very important. The fact is that people are trafficked in a situation of social vulnerability. They are obliged or induced to accept exploitative employment or situations, and very often they find themselves in situations, in conditions of a slavery-like condition. So we can say that trafficking can be compared to slavery or a slavery-like practice. And the dimension of trafficking, there are recent estimates produced by the International Labour Organization together with the Walk Free Foundation, talking about 40 million people in modern slavery, out of which 15 million people in forced marriage and 25 million people in forced labor, which in the definition of the ILO comprises commercial forced sexual exploitation. Globally, 71% are women and girls, and 99% of women and girls in forced sexual exploitation represent, of course, the vast majority of victims in this particular field. These estimates are not, the methodology is questionable, but anyway, they give, the idea that we are talking about a massive phenomenon. So we're talking about a phenomenon which is mostly hidden, because if we look at the numbers, the statistics, the official statistics of identified victims and perpetrators, we're talking about a huge gap, which means that the vast majority of victims of trafficking are still not identified, not supported. They don't enjoy any right, even the rights, limited rights recognized by the anti-trafficking legislation. The definition of trafficking is encompass three elements: acts, means, and purposes. The acts are recruitment, transfer, or receipt, or harboring of people. And differently from what it is currently believed, this does not necessarily imply movement. And for sure does not imply transnational movement. Because we have other components. We have recruitment, which means, mediators, which means also employers sometimes. But we have also receipt. And receipt, in the terminology and the interpretation established by experts of the ILO, the International Labour Organization, includes receiving a labor performance. So this means that even without any transfer, even without any movement, employers employing, if all the other elements are present, employers can be charged with trafficking. The means are basically, I simplify, violence, deception, and abuse of a position of vulnerability. So violence doesn't need any explanation. Deception either. Abuse of a position of vulnerability is the most difficult concept because, of course, this identifies the subtle means of coercion that are used more and more by traffickers to create, to manipulate the victim, to create dependency, and even attachment, as in the case of the so-called lover boys, which is one of the forms of recruitment of girls, young girls, for the purpose of sexual exploitation. And this abuse of a position of vulnerability should be seen together with another provision of the definition, which is about consent. The consent of a person is not relevant when any of the means have been used, the illicit means have been used. If violence is used, it's clear, consent is not valid. Abuse of a position of vulnerability identifies the situations in which it is not very easy. In many cases, it is not easy at all to distinguish a valid consent from a consent which has been obtained by the use of a position of, by the abuse of a position of vulnerability. The purposes are not an exhaustive list. The general purpose is exploitation, which includes sexual exploitation, slavery, forced labor, servitude, removal of organs, but of course, being a non-exhaustive list, the national legislation can add other illicit purposes. So the exploitation as the purpose of the mens rea doesn't need to be proved in factual terms, but of course, the purpose itself needs to be proved, through circumstantial evidence. This definition is subject to criticism from practitioners, from the side of practitioners, for its complexity. And it is very often difficult to gather evidence about all these elements, sometimes very difficult also to interpret in concrete cases. Although some of this criticism sometimes also comes from insufficient training, insufficient knowledge and understanding of the legal definition and all the technicalities implied by the legal definition. But the most important and well-founded criticism is about the legal basis of the definition of trafficking, which is the optional protocol supplementing the Convention on Transnational Organized Crime, so a criminal law instrument, adopted in 2000, widely ratified, because there are serious gaps in human rights terms in this global instrument, which is the only global instrument on trafficking. Although in the very last phase of the negotiation, the protection of victims was added as one of the main purposes of the protocol, still the provisions concerning assistance and support to protection to victims are very weak, non-binding, mostly non-binding. The only binding provision concerning victims' rights is the provision on compensation, which is unfortunately very rarely applied. No possibility, the provision about the residence status is particularly weak, the language is particularly weak, and it's of course not binding. And no possibility, none of this, entitlements is justiciable. So we cannot talk in legal terms about rights, but about the possibility to grant some assistance, support measure. The Council of Europe Convention of 2005 overturned the approach. So we can see in the Council of Europe Convention a genuinely human rights approach. The measures are more, precisely identified. The relevant provisions are binding. Assistance must be unconditional. Unfortunately, as a compromise, the provision concerning residence permit for victims has been agreed in the sense that states have an option. They can decide to grant residence permit on the basis of a personal condition of the person and or on the basis of cooperation of the victim in criminal proceedings. This means that states, and the vast majority of states have chosen this option, can make the residence permit conditional to the cooperation of the victim in criminal proceedings, which means that at least for foreign victims, also assistance is in fact conditional, because if they don't get a residence permit, of course they cannot stay in the country and they cannot be assisted. The European Union directive adopted the European Directive of 2011 is a criminal law instrument, but anyway, took a step forward concerning victims' rights in criminal proceedings, as Siobhan said. Unfortunately, the problem of the residence permit was not solved even there, because even though assistance is unconditional, a previous directive, which was not abrogated, established that residence permits for third country nationals are conditional. So this is more or less the legal basis of trafficking concerning binding instruments. But we have to take into account also the so-called soft law instruments, which are very important in this case, because they fill some of the gaps in terms of human rights approach. So at the national level, it is important to push for the implementation of this instruments, which are the recommended principles and guidelines of the Office of the High Commissioner for Human Rights. And importantly, the recommendations, the general recommendations of the CEDAW committee, the body in charge of the monitoring of the implementation of the Convention on Discrimination against Women, which in the interpretation of the CEDAW committee includes violence and trafficking. So regarding the nexus between trafficking and conflict, this nexus has been until very recently completely overlooked. Recently, we had a very important endorsement by the Security Council of this relationship, very, very, concerning nexus, starting with the presidential declaration of 2015 under the US presidency of the Security Council. It was the end of the Obama administration. And then in 2016 and 2017, two subsequent resolutions were adopted by the Security Council. I will go back to this in a few minutes. From a factual point of view, what are the, the situations, the factual situation in which we can, acknowledge the importance of this nexus? In all the 13 countries that have been listed by the Secretary General in his recent report of 2009 and previously in 2019 and previously 2018, there are 13 countries listed as countries affected by conflict. In all these countries, incidents of trafficking have been reported, even in a situation in which the attention is not so high to trafficking as an integral component of a conflict situation. We have to say that this situation are mostly situations in which the conflict is between an armed group and the state, or between armed groups between each other. And in this context, trafficking is used, firstly, to increase directly the offensive power of an armed group. And this is the case of the recruitment of child soldiers, or the kidnapping of girls reduced to sexual slaves as part of the reward or the salary of combatants. Also the recruitment, sometimes forced, sometimes not, but this result in forced labor of people used as servants to cook, to provide any kind of services to the troops. Many incidents of trafficking have been reported among forcibly displaced populations, which are particularly vulnerable to trafficking. Displacement implies limited access to resources for many years. Sexual violence by armed groups is unfortunately a current situation. And people are sometimes victim of a cycle of violence, because people subjected to sexual violence are subsequently trafficked, also because of the stigma, also because of they are refused by their community. But it also true the same, because trafficked people once have been trafficked, even many years after they have severed their situation of trafficked person, they can be a victim of sexual violence and domestic violence. People fleeing conflict are also particularly vulnerable to trafficking, being obliged to leave the country in unsafe condition. Traffickers ask for more money during their journey, and refugees are compelled to accept exploitative situations to resume their journey. They find themselves in countries not necessarily in a friendly social environment. And if we look at the situation in the Mediterranean and the humanitarian disaster which is happening there, with so many people still dying in the Mediterranean during their journey, we can see that according to research carried out 2 years ago, if I remember well, by IOM, people arriving in Italy through the central Mediterranean route, something like 80% of them reported that they themselves or friends had been subject to situations, at least to one of the situations that IOM indicated as indicator of a trafficking situation. The aftermath of the conflict is also a situation in which people are trafficked on a regular basis. The breakdown of the rule of law, the difficult economic situations, the persistent discrimination against women in the peace-building phase, all these factors increase vulnerabilities. But on top of it, there is also the normalization of violence, which happens during the conflict, that creates a favorable environment for trafficking in the aftermath of the conflict. Finally, trafficking unfortunately occurred during peacekeeping operations. And this is really a shame, including by operations led by the UN. Strong measures have been adopted, I have to say, but the problem is far from being solved so far. As I said, what emerged from all the research I consulted in preparation of my reports on this subject, trafficking is not occasionally linked with conflict. It is a consequence on a regular basis of conflict. And this, of course, has some implications, operational implications. which means that trafficking should be considered, anti-trafficking, prevention of trafficking, should be considered a life-saving activity by people in the field. This means that trafficking should be, anti-trafficking activities should be funded by states and also by donors without the so-called evidence-based requirement. This is not needed. We know that in all situations of conflict, and even years after the conflict is officially over, still situations of trafficking occur. This approach is partially adopted, included in the Security Council resolutions. I say partially because it is not so clear what I said about the fact that, trafficking must be considered a life-saving activity from the onset of the conflict, but at least the nexus has been acknowledged. But criticism has been expressed by scholars, especially concerning the fact that the Security Council adopted a so-called hard security approach. So the focus is mostly on trafficking linked with terrorism, terrorist groups. And so whatever has been said is said, if we see this from a human rights approach, only in relation to a certain type of victims. And we know, how dangerous is to discriminate, to separate one category of victims from another category of victims. So it is important that the Security Council acknowledged the nexus. This is a starting point, but and this is what I had advocated for in my recent reports. We should push for an integration between, the Security Council resolutions, the Women, Peace and Security Agenda, which is also a Security Council agenda, but was pushed and designed by the civil society, by the women's movements. So it has a genuinely human rights approach, and the recommendation, the CEDAW committee recommendations. And this is not easy because in the UN system, it is very difficult actually to make all these different bodies and silos to talk to each other. And in the case of the Security Council, there is also a political resistance of some states to include a human rights-based approach in the work of the Security Council as a whole. But I think this is a piece of work we have to do. I don't know if there will be a follow-up to my report, but I have been advocating for an integration between the Security Council recent resolutions on trafficking and the Women, Peace and Security Agenda. The Women, Peace and Security Agenda is an agenda which values women's agency, that challenges the narrative of women as necessarily victims and only victims of violence. And especially the participation pillar can, represents an added value in the prevention of trafficking in conflict. It has been acknowledged that when women are mediators, signatories, are an integral part of the peace-building process, these agreements have a higher probability to last and to create a transitional, positive transitional phase. And of course, when women are, part of the decision-making process, they understand, the economic situation, especially, in situations in the aftermath of the conflict, and suggest measures to, prevent trafficking, protect women, especially people that have lost their families, can suggest community-based networks capable to avoid that people leave the country in unsafe conditions. There is another piece of the legal context I would like to very briefly mention, which is the International Criminal Court Statute. The International Criminal Court Statute includes enslavement among the crimes against humanity. And it is said that enslavement includes, situations, the exercise of the power of ownership on another person in the context of trafficking. So it is clear that the negotiators of the Rome Statute wanted to explicitly mention trafficking, to make it clear that enslavement also encompasses this crime. In addition, sexual slavery, together with forced pregnancy, sexual violence, and other crimes, are listed as crimes against humanity and war crimes. Of course, this is an important opportunity to fight impunity. Impunity, we know that is almost, it's the global reality concerning trafficking, conflict-related sexual violence, etc. I have to say that so far, strangely enough, the International Criminal Court, which is the court established as a consequence of 2000, a permanent criminal court, has not dealt with any case of enslavement or slavery or trafficking. But the previous ad hoc courts established for the Yugoslavia, for the former Yugoslav conflict in the former Yugoslavia, for Sierra Leone, and for Rwanda, they had dealt with trafficking cases, enslavement cases. And I have to say that if we look at these cases, we can understand that the jurisprudence on trafficking, national jurisprudence on trafficking, and the jurisprudence of the International Court, of the European Court of Human Rights on one side, and the jurisprudence of the International Criminal Court concerning enslavement and trafficking is somehow showing similarities. And in particular, similarities are very clearly showed in cases in which the victim is manipulated. So, for example, emotional abuse and humiliation is considered by courts as a component of trafficking cases. And in cases, in the case Kunarak and Katanga, for example, the ICTY, the Court for the former Yugoslavia, the Court of Appeal upheld a broad concept of ownership and found that the abuse of power, the victim's position of vulnerability, psychological oppression, or socio-economic conditions are relevant indicia of control and ownership. So you can see that, this gray situation of, control of the person obtained by psychological manipulation, for example, is recognized as an element of trafficking on one side and enslavement and slavery on the other side. The last piece of legal context I would like to mention to you is trafficking as encompassed within the concept of conflict-related sexual violence. I say legal context in general terms because there's no legal definition, binding definition of conflict-related sexual violence. But anyway, there are authoritative sources. The most recent, report of the Secretary General on conflict-related sexual violence. Sexual violence in this report of the Secretary General is defined as encompassing rape, forced pregnancy, forced sterilization, forced abortion, forced prostitution, sexual exploitation, trafficking, sexual enslavement, forced circumcision, castration, forced nudity, or any other serious form of sexual violence, and refers to incidents or patterns of sexual violence against women, men, girls, or boys, occurring in a conflict or post-conflict setting that has direct or indirect links with the conflict itself, or that occur in other situations of such as in the context of political repression. So what are the implications of this definition and of the fact that trafficking is considered one of the possible forms of conflict-related sexual violence? And this is a quite new exploration that I try to do with you today and to discuss with you today. In my view, an important implication of the definition contained in the Secretary General Guidelines of 2014 on reparations of victims of conflict-related sexual violence is that conflict-related sexual violence should be considered as such, not only when it is directly committed by armed groups, not only when it is committed during conflict or post-conflict, not only when it is committed against people fleeing conflict, and not only in the interest of armed groups. So we are, dealing with a very, very broad definition. And this broad definition has multiple repercussions regarding trafficking in persons. Firstly, we have to think that it is to be considered conflict-related sexual violence, the obvious case of trafficking perpetrated directly by an armed group. And this is the case, for example, of Yazidi women reduced to sexual slavery by ISIL Daesh. Secondly, the second case is the kidnapping of women belonging to a different ethnic community. So again, trafficking perpetrated by directly by an armed group, as it happened in the former Yugoslavia, in Bosnia. Thirdly, when an armed group, again, we are talking about trafficking that committed directly by an armed group, when the group sells someone to a criminal gang as a form of financing of the armed group. And this is most probably what happened to the girls kidnapped by Boko Haram in Nigeria, or in part also to women kidnapped in Syria and Iraq by ISIL Daesh. Fourthly, trafficking in person can be considered as encompassed within the notion of conflict-related sexual violence when it is committed not directly by an armed group, and not in the interest of an armed group, but rather by a criminal gang taking advantage from the situation of breakdown of institution and the rule of law during conflict and post-conflict, including taking advantage of vulnerabilities deriving from the attempt of vulnerable people to leave the country, or taking advantage of the situation of vulnerability linked with displacement. And there, this case is particularly interesting because armed groups are not involved directly. So it is someone else taking advantage of the situation of vulnerability created by the conflict or the conflict aftermath. And finally, a criminal group can commit trafficking in person by taking advantage of situations of displaced people even many years after the conflict. We know that the situations of displacement can last for a very long time, and we cannot exclude that people trafficked from camps even years after the conflict, being people that are in a situation of vulnerability as a consequence of the conflict. We cannot exclude that this form of trafficking is a conflict-related sexual violence. And there I don't agree with other scholars concerning the question, when does conflict-related sexual violence end? When there is no link between the perpetrator and the conflict? No, I say when there is no link between the victim and the conflict. As long as the victim vulnerability created by the conflict, provocated by the conflict lasts, there is still conflict-related sexual violence. Another consequence of that definition is that we, the Secretary General actually, talked about incidents or patterns of trafficking. So even individual cases, not necessarily trafficking happening in a more complex pattern, for example, to prosecute a case before the International Criminal Courts, enslavement as a crime against humanity must take place as a part of a systematic attack against civilians. In this case, we talk about the conflict-related sexual violence, even in a case in which there's no pattern. There is an individual, an individual induced, for example, and this, I have seen the multiple cases of this kind in Jordan, in camps, in refugee camps where victims of the Syrian conflict are. The family arranges a marriage with a foreigner, sometimes just as a negative coping mechanism, trying to avoid that the daughter stays there in camp for forever. They don't realize that this man asking for marriage as a second or third wife will reduce this person or in a situation of servile marriage, or even will sell this girl into forced prostitution. Sometimes there is a complicity of the family really selling their daughter to have money to survive. I'm fully aware, and this is a warning concerning all that I said during this presentation, that some of these cases I've referred to, are not currently labeled as trafficking. But this is the result of a narrow and, in my view, incorrect interpretation of the legal definition of trafficking. Because if you see, for example, the case I mentioned of the Yazidi women, in this case, the act is kidnapping. The means is violence, and the purpose is sexual exploitation. All the elements are there. And even in the most difficult case of the early marriage, again, the act is to, from the side of the perpetrator, which is the man asking for false marriage and selling the girls into forced prostitution. From the side of the man, this is receipt, is the act, and the means is deception about the purpose. And the purpose is sexual exploitation. So you can see that all the elements are present. What are the consequences of this, inclusion of trafficking within the concept of conflict-related sexual violence? I think that, again, people in the field should be aware of this link, and all the measures, all the preventive measures, all the measures regarding reparations should also include victims of trafficking. Action plans, programs, projects should include trafficking in their scope, and you see that this is crucial. This is not only important. This is imperative, because trafficking in conflict context is not considered. Is not considered at all. It is considered a matter of. It is considered something for development people. You can confirm that, again, the silos are completely separated. There are people dealing with conflict and emergency life-saving, measures, and people dealing with development. And we see that, all of them should cooperate to try to find out what are the right solutions to prevent and to remediate to trafficking in these situations. reparations. Reparations is a very important chapter of the human rights of victims. Reparations include restorations, include the guarantees of non-repetition, satisfaction, compensation, restitution. It's not only compensation. There are, a number of measures that, especially concerning, so-called post-conflict situation, even if the definition is questionable, but just to understand, transitional justice, very much transitional justice, are absolutely crucial for victims to rebuild their life psychologically and from a material point of view. And reparation should have a transformative nature and a transformative component, because, for example, guarantee of non-repetition means to address, to deal with all the root causes of trafficking, including discrimination, gender discrimination, in terms of also of programs, in terms of education, in terms of employment, etc. Recovery, rehabilitation, there, on the contrary, I would like to say that the experience gained in anti-trafficking action worldwide is a precious hub of knowledge and concrete practices that can be used by people in the field to design reparation programs for victims. There are particular aspects of reparation or remedies which are specific for trafficking. And that should be taken into account when designing reparation programs. For example, restoration includes restoration of liberty, because as a consequence of the non-application or rare application of the provision of non-punishment, which is binding in the Council of Europe Convention, but is not binding in the global instruments, very often the people are detained, are incarcerated for violation of the immigration laws or for crimes they have been induced to commit in direct link with their situation of trafficked persons. So this means restoration of liberty. This means family reunification, which means, although it is not the case maybe for conflict-related sexual violence, but in general terms, very importantly, means restoration of employment, which in cases of labor exploitation is what victims primarily need. A few words in conclusion. It is time to think how to fill the gaps in the current international legislation on trafficking and to adopt a genuinely human rights-based approach to anti-trafficking. As I said, there is a lot to do, really a lot. And we have to think that a human rights approach is not a victim-centered approach. It does not only mean that legitimate interests of victims must be at the center of anti-trafficking action, which is correct and which should be there. But human rights approach means that victims are right holders, and this means that all the entitlements, benefits that legislation recognize should be justiciable, which is not the case nowadays. So, for example, one of the most important, I think, innovation changes that we should advocate is the possibility of an appeal against the negative decisions of competent authorities about recognizing the situation of a victim of trafficking. Moreover, given that exploitation is a continuum, there are cases of trafficking that very, very clearly, can be located at the end of the spectrum, so it's extreme exploitation, but also due to the narrow interpretation given by criminal courts of the legal notion of trafficking, slavery, and forced labor. Many situations in which exploitation is severe but not so extreme do not fall within the legal qualification of none of these crimes. And this means that maybe we should explore the concept and the notion of exploitation, which is the common denominator to all these crimes, and think about a new instrument or soft law document directly addressing exploitation. However, for the moment, what everybody should do, and altogether we should do, is to promote a systematic and joint interpretation of the Palermo Protocol, the Security Council resolution, the Women, Peace and Security Agenda, the CEDAW General Recommendation, and the Greta Recommendations, and the Conflict-Related Sexual Violence Agenda, to build a system that is human rights, really human rights based. From this point of view, I have to say that despite all the gaps I have mentioned, the practice, the anti-trafficking practice, especially carried out by civil society organizations worldwide, show a number of, have a number of merits, have managed to overturn sometimes the legal approach into a very, very effective human rights-based approach. So this is also something that something to study, something from which we can learn every day. But I still have the dream that one day we could have a new instrument, global instrument, summarizing and taking a step forward including regarding the nexus between trafficking and conflict. Thank you. So of course I'm ready.